I've been doing this for a long time, a very long time. And let me tell you something. In all my years on the bench, I have seen every flavor of foolishness that a human being can cook up and serve to a judge. But every now and then, a case walks through those doors that reminds me exactly why I show up every single morning with my robe pressed and my patience ready. I said ready, not unlimited. Ready. Let me tell you about Gabriela Sanchez. She walked into my courtroom 19 years old. 19. I have shoes older than that. She was charged with aggravated assault with a deadly weapon, a second-degree felony in the state of Texas. And let me tell you what that means in plain English, because I don't do complicated when simple will do just fine. Second-degree felony, up to 20 years in prison, up to a $10,000 fine. 20 years, sweetheart. You'd be nearly 40 before you saw daylight as a free woman. Her attorney was present, the state was present, and I, Judge Judy Scheindlin, was sitting right behind that bench ready to get to the bottom of things, because that is what I do. The courtroom was dead silent. You could hear the air conditioning. You could hear people breathing. And every single person in that room knew, including Gabriela Sanchez, that what happened in the next few minutes was going to determine the entire direction of her life. Now, before any plea gets entered in my courtroom, I go through everything, every single thing, because I am not going to have somebody stand in front of me, agree to terms, walk out that door, and then come back later telling me they didn't understand. Oh no, that does not happen here. Not on my watch. Not ever. So I walked her through it all. I told her, if this court grants your application for deferred adjudication, and if for any reason that deferred adjudication is revoked, meaning you mess it up, meaning you don't follow the rules, meaning you act like this is optional, this court can find you guilty and sentence you to up to 20 years in prison and a $10,000 fine. Did she understand? Yes. I turned to her attorney. I asked whether his client had any defenses, whether she had a rational and factual understanding of what she was charged with, whether she was competent, whether she had been legally sane at the time of the offense. These are not small questions. These are the architecture of a fair proceeding, and I build them carefully every single time. Her attorney confirmed everything was in order. Then I looked back at Gabriela. Had anyone threatened her, pressured her, put her in fear to get her to enter this plea? No. Anyone promise her anything outside of this agreement? No. Was she satisfied with her legal representation? Yes. Was she a United States citizen? Yes. Good. We could proceed. I walked her through the plea bargain page line by line. $1,500 fine. Affirmative finding of a deadly weapon. And I want everybody listening to understand what that means, because it is not a footnote. An affirmative finding of a deadly weapon in Texas affects parole eligibility if this young woman were ever sent to prison. It follows you. It is a serious designation, and I do not gloss over serious things. The state was recommending deferred adjudication. There was a companion case being taken into consideration, and there was to be restitution, if any, to 3 people whose names I will say clearly because they deserve to be acknowledged. Jose Caceres, Miguel Rosas, Ashley Alameda. Real people, not abstract concepts. Real human beings whose lives crossed paths with this defendant. I asked the defense, is that the plea? Yes, Your Honor. I asked the state, is that the plea? Yes, Your Honor. I reviewed her waiver of appeal. She had signed it in both places. She understood that by signing, she was surrendering her right to appeal. The only items eligible for appeal would be written pre-trial motions that had been filed, heard, and ruled upon. Her attorney confirmed no such motions existed. Then the state outlined what they were recommending beyond the agreement itself. 10 years of deferred adjudication, a TAP evaluation, 250 hours of community service, restitution, no contact with the victims. And I made it crystal clear to her, these are the state's recommendations. This court does not have to follow them. I am not a rubber stamp. I make decisions based on what is in front of me. Did she understand that? Yes, Your Honor. Then the moment arrived to the offense charged. How do you plead? Guilty? Not guilty or no contest. She hesitated just for a fraction of a second, but I caught it. I always catch it. That tiny pause where a person is standing at the edge of a cliff, deciding whether to jump or step back. The whole room held its breath. No contest. The state offered its exhibits. No objection from defense. I reviewed the stipulation of testimony, the police reports, the documentation, and I found, as I expected I would, sufficient evidence to support a finding of guilt. But I deferred that finding. That is what deferred adjudication means. It means I am choosing, as an act of judicial discretion, not to slam that gavel down on a final conviction today. It means I am giving this young woman an opportunity, a window, a chance to prove to this court and to herself that she can do better. That is not a small thing. Don't let anyone tell you that's a small thing. Subscribe now because you are going to want to see how this ends. Trust me. Here's where it gets interesting because I am not a conveyor belt. I am not here simply to process paperwork and move bodies from one side of the courtroom to the other. When a young person stands before me, especially a 19-year-old on a weapons charge, I want to know who they are, what made them, what they're working with, what they're working toward. I do this because conditions of probation are not one size fits all. They should mean something. They should address something real. So I started asking, if she were drug tested today, what would the results show? She told me marijuana. I had just had another defendant in my courtroom test positive for marijuana not moments earlier. So I pressed, anything else? No, ma'am. All right, I noted it. Then I asked her, why are you using marijuana? And she said, just to use it. I leaned forward slightly, just enough because in my courtroom, when I lean forward, everyone notices. The attorney noticed, the bailiff noticed, and Gabriela Sanchez most certainly noticed because what she had just said was not an answer, and she was about to find that out. Honey, just to use it, that is not an answer. That is the absence of an answer wrapped in a shrug. You're using a substance that is illegal in the state of Texas, illegal while on probation, and the reason you're using it is just to use it. I told her plainly and directly, that stops now. You are on deferred adjudication. Marijuana is not legal in Texas. It is not legal on probation. It is not a gray area. It is not something we're going to debate. It stops. Are you employed? No, Your Honor. How are you supporting yourself? My boyfriend. I see. Any children? No. Where are your parents? They're outside. Outside in the hallway. Now, that caught my attention. You have people who cared enough to show up to your court date, and you've got them sitting in a hallway. So I asked, do they know what's going on with this case? She wasn't sure. They just showed up, she said, and she didn't have a good relationship with them. I asked why, and I want to be clear about something. I was not prying. I was not being nosy. When I ask those questions, it is because I need context. If there is trauma in this young woman's past, if something happened in that home that wounded her, then I need to factor that into the conditions I'm setting. Maybe she needs counseling. Maybe she needs therapy. Maybe there's a reason she's making the choices she's making that goes deeper than bad judgment. But if the situation is simply that her parents have rules and she doesn't like them, and she moved out to live with her boyfriend on her own terms, that is a different story entirely. One is a wound, the other is a choice, and I treat them very differently. So I asked again, what are the issues with your parents? My father mistreats me. The courtroom shifted. I felt it before I saw it. That one sentence, quiet, almost reluctant, landed differently than anything else she had said. And for a moment, this wasn't a criminal proceeding anymore. It was something more human than that, something heavier. I heard that, I took it in, and I moved forward accordingly. I set proof of employment within 30 days, no employment as a home health care provider or in positions working with minors. Given the nature of this charge, a deadly weapon finding, those restrictions were not arbitrary. They were necessary, and they were non-negotiable. How far did you go in school? I graduated high school. Good, a foundation, something to build on. Then I asked her the question that seemed to catch her off guard. What do you want to do with your life? Not what do you need to do, not what are your obligations. What do you want? What are your hopes, your dreams, your aspirations? She thought about it for a moment, and then she said, performing arts, theater. Now, I have heard a lot of answers to that question over the years. Some people stare at me blankly. Some people say they don't know. Some people give me an answer they think I want to hear. But she said theater. She said it quietly, like she wasn't sure she was allowed to want that anymore, like the courtroom had already taken it from her. I wasn't going to let that stand. I told her about Lauren Bacall, one of the greatest Hollywood actresses who ever lived. Before the fame, before the films, before Humphrey Bogart, she was working in a theater, a cigarette girl. That's where it started, not on a stage in the spotlight, in the back of a theater handing out cigarettes and watching and learning and staying close to the things she loved. I told Gabriela Sanchez, if you don't work toward your dreams, they do not happen. Nobody is going to walk up to you on the street and hand you your future in a gift bag. You have to go get it. Every single day, you have to go get it. And then I made her an offer. If she enrolled in college or a trade school, genuinely pursuing something, moving towards something full-time, at least 9 credit hours, I told her this court would consider waiving her 250 community service hours. The choice was hers. She could do the community service. She'd learn something from it. I always say you learn something from community service. But if she wanted to invest in herself, if she wanted to actually chase that dream she just told me about, I was going to give her the runway to do it. That is not something every judge offers. Remember that. I laid everything out on the record, clearly, completely, with no room for misunderstanding. 10 years of deferred adjudication, affirmative finding of a deadly weapon, $1,500 fine, proof of employment within 30 days, no employment as a home health care provider or working with minors, restitution to the victims, 250 hours of community service, waivable upon enrollment in college or trade school, anger management, regular reporting by Zoom or in person, regular urinalysis testing, field visits once a month for the first 3 months. After 3 months with no issues, probation could adjust the schedule. TAP evaluation, no contact with Jose Casares, Miguel Rosas, or Ashley Almeida. I asked probation if she needed anything else. I asked if there was anything further the court could provide. Then I showed Gabriela the trial court certification of her right to appeal, reviewed, understood, signed, because this was a plea bargain agreement, because she waived her right to appeal. This court's decision was final. She did not have my permission to appeal. Did she understand? Yes, Your Honor. We prepared to go off the record, and before we did, I looked at her one more time, and I said what needed to be said. This could have gone south so quickly. You could be looking at prison time. Think before you act. She said, yes, Your Honor. I told her good luck, and I meant it. She was directed to remain in the courtroom so probation could go over her conditions. I also asked probation to run a drug test, not for levels specifically, just a baseline screen to see where we were starting from, and I moved on to my next matter. If you are still with me, go ahead and subscribe now because this story is not even close to over. I had moved on. I was in the middle of the next case on my docket, but I need to tell you what happened with Gabriela Sanchez first because the drug test came back and she was called back to stand in front of me. The first thing I noticed, and I noticed it immediately because I notice everything, was her clothing. Inappropriate for a courtroom. Now listen, I don't care what you wear to the grocery store. I don't care what you wear to the movies. But when you walk into a court of law, you dress with respect for where you are. That tells me something about how seriously you are taking your situation, and what she was wearing told me she was not taking it seriously enough. But that was the small problem. My probation officer looked at me. I've been doing this long enough to read a face before a word is spoken. And right there, in that single look between me and my probation officer, the entire atmosphere of the courtroom changed. Whatever warmth had existed during the plea, whatever hope had been built during our conversation about theater and Lauren Bacall and college, it evaporated. Just like that, the room went cold. I said it without preamble. You're positive for cocaine as well. Now, let me describe what happened next. This young woman, who had just stood before me not an hour earlier, who had just received deferred adjudication on a second-degree felony, who I had just talked to about Lauren Bacall and theater in college, looked at me like I had said something impossible. She said she didn't use anything other than marijuana. She insisted on it, said she had never used cocaine. I'm going to tell you what I told her. When you buy drugs off the street, and I am talking to everyone right now, not just Gabriela Sanchez, there is no label on the outside of what you're buying. Nobody has inspected it. Nobody has certified what's in it. You do not know, and you cannot know what your supplier has put into that product. If she was not intentionally using cocaine, then whoever she was buying her marijuana from was lacing it. That is a documented reality. That happens, and it is exactly why I tell people, when you use street drugs, you are rolling the dice with your life every single time. But here's the thing. Here's the part that I need everyone to understand. I don't care why the cocaine was there. I am not in a position to care why. The condition was no drugs. Not no drugs unless someone put something extra in yours. Not no drugs unless you didn't mean to. No, drugs, period. She stood there, and I watched the realization wash over her face, slowly, painfully, like cold water, that the second chance she had been handed less than 60 minutes ago was now slipping right through her fingers, and there was nothing she could say, nothing she could do. The test result was the test result. She had been on her deferred adjudication for less time than it takes to watch a movie, less time than it took me to explain her rights to her, and she had already violated it. I asked her if she and her boyfriend were using the same supplier. She said no. I asked where the boyfriend was. Had he left already? He had. He was probably outside waiting for her. Her parents were still in the hallway. Let me paint that picture for you one more time. This girl had a boyfriend waiting outside, parents in the hallway who showed up without even knowing exactly what was happening, and a judge who had just offered to waive her community service hours so she could go pursue her dream of performing arts. And she tested positive for cocaine. I have seen a lot of things in this courtroom, a lot, but there is a particular kind of heartbreak that comes from watching someone receive a gift and drop it on the floor in the same moment. Her deferred adjudication was now in jeopardy. If probation moved to revoke, and they had every legal basis to do so, she would come back before me. And at that point, I would not be the judge talking about Lauren Bacall. I would be the judge entering a final finding of guilt on a second-degree felony, up to 20 years. That stage she wanted to perform on, gone. Now let me tell you about the second defendant on my docket that day, Jose de Jesus Gigus, 29 years old, married, father of 2 children, a 7-year-old and a 2-year-old. He went through the 11th grade, and here is what I found notable about this man. He owned and operated his own paint and body shop right there in town. He had built something. He had employees depending on him. He had a family depending on him. He had entered a plea of no contest on May 1st, and we were convened today for sentencing. His attorney raised something important before we proceeded. Mr. Gigus was not a United States citizen. Now that changes things considerably, because a criminal plea can have immigration consequences that are permanent and devastating. Consequences that extend not just to the defendant, but to his wife, to his children, to his entire life in this country. An organization called MAC had prepared a 6-page memorandum outlining every immigration consequence of his plea. His attorney had gone through all of it with him. They were prepared to proceed. I looked at Mr. Gigus carefully before I said another word, because this was a man carrying something heavier than most people in that courtroom understood. A criminal record, even a deferred one, could mean deportation. It could mean separation from his wife, from his 7-year-old, from his 2-year-old. It could mean losing everything he had built with his own 2 hands. That weight was in the room, even if nobody was saying it out loud. I asked Mr. Gigus directly, "Are you asking to proceed?" "Yes, ma'am." "Good." We had no interpreter present, so I asked him directly on the record, "Can you understand the English language?" "Yes, ma'am." Had he reviewed all of his documents in English and understood them? "Yes, ma'am." His attorney spoke on his behalf, gave me the full picture. 29 years old, married business owner, 2 small children at home, no CPS involvement. I asked about the drug test. What would it show if we tested him today? He said it would probably be positive for marijuana. I asked, what else? He said, just marijuana. And then he added something, almost as an afterthought. He mentioned, carefully, hesitantly, that he wasn't entirely sure how long cocaine stays in the system, because he said he had been previously charged with that. I set my pen down, slowly, deliberately, because when I set my pen down in the middle of a proceeding, everyone in that courtroom knows something just shifted. His attorney stiffened slightly. The state paid attention. And Mr. Gigos, to his credit, did not look away. I heard it, I filed it, and I told him we would see what the test showed. I set his conditions. 3 years deferred adjudication, shorter than Ms. Sanchez, reflective of the differences in their charges and circumstances, $1,500 fine, probated, 100 hours of community service, with the provision that completing parenting classes would satisfy those hours in full. Because this man had a 7-year-old and a 2-year-old at home, and what they needed more than anything was for their father to be present, equipped, and responsible. Restitution, DWI education, victim impact panel, TAP evaluation with the court following TAP's recommendations. Though if inpatient treatment was recommended, we would begin with supportive outpatient treatment, regular urinalysis testing for levels, regular reporting by Zoom or in person, field visits once a month until further notice, proof of employment within 30 days, no employment as a home health care provider or with minors, 90 sober meetings in 90 days, no license suspension. I asked probation if there was anything else he needed. I asked Mr. Gigos directly, is there anything you need from this court to be successful? No. I showed him the trial court certification of his right to appeal. He understood he had waived that right. My decision was final, and then we went off the record. Go ahead and subscribe now, because what I said next is something every parent needs to hear. You have children in your house, a 7-year-old and a 2-year-old. You cannot be smoking marijuana. And I'm not finished. Do not look at the floor. Look at me. Some people think that smoking outside makes it acceptable, that if you step into the backyard or drive around the block, somehow the children are protected from it. Let me disabuse you of that notion right now. When you come back into that house after smoking, you carry it with you. It is on your clothes. It is in your breath. It is in your hair. And those 2 little children whose brains are still developing, who are at the most critical stage of learning what the world is, they smell it. They absorb it. You might as well pass it to them directly. Would you give your children marijuana to smoke? No, ma'am. Then what are you doing bringing it into their environment? Children do not learn from what you tell them. They learn from what you do. That is how they develop language, by watching and mimicking. That is how they understand behavior, by observing the people they love most in the world. When you see a small child using profanity, you know where it came from. It came from the people around them. Your 7-year-old is watching you. Your 2-year-old, who is barely old enough to form sentences, is absorbing everything you do as the definition of normal. And one day, not so far from now, those children are going to look back at who their father was during these years, during the years that mattered. And I am asking you right now to be a man they are proud to call their dad. You have a business, you have a wife, you have 2 children who need you. All of it, every bit of it can disappear if you stand in front of me again. Don't stand in front of me again. Yes, ma'am, I understand. Good luck to you. Here is my answer, and it has never changed. Because somebody has to. Because if I am not thorough, someone walks out of my courtroom without truly understanding what just happened to them. Because if I am not firm, the conditions mean nothing. But if I sit up there and process paperwork without looking at the human being standing in front of me, if I don't ask about the dreams and the parents and the children and the future, then I am not a judge. I am a machine in a robe. I am not a machine. When Gabriela Sanchez told me she wanted to perform in theater, I told her about Lauren Bacall, not to fill time, not to hear myself talk. I do not need help with that. But because I wanted that 19-year-old girl to understand that her dream was real, that it was worth protecting, that the conditions I was setting were not punishments, They were a framework designed to keep her free long enough to actually pursue it. When Jose Chigos told me he had a 7-year-old and a 2-year-old at home, I thought about those children sitting in that house waiting for their father to come through the door. And I needed him to understand that the version of himself he showed up as at home every single day was the version they were going to carry with them for the rest of their lives. That is why I go off the record and say what I say. That is why I ask questions that have nothing to do with the charge on paper, because the charge on paper is not the whole story. The person standing in front of me, the scared 19-year-old, the father of 2 who built his own business, every single one of them. That is the whole story. And for whatever reason, through whatever strange and winding path life has taken, I am the one sitting at that crossroads with them. So I take it seriously every single time. Don't waste the second chance, and for heaven's sake, don't come back to my courtroom. Judge Judy has spoken. Court is adjourned. Bye-bye.